to see you.
Okay, now I unmuted.
How are you doing?
Good. How are you? How is everything going?
Fine, fine. Thank you so much for joining us today.
Thank you very much. It's my pleasure.
Thank you. So we'll be starting very soon.
Yeah.
Michelle will be anchoring the session, so she'll be taking it up from here.
Oh, I see. Michelle. Okay. Hi.
Good evening.
Hi, good evening.
All right, so good evening, everybody. My name is Michelle. Should we wait for everybody to join or we should just go ahead?
Yeah, I think we should go ahead.
Okay, so my name is Michelle Babasui. Long story short, I was a previous mentee at this internship program. Today, we're going to, first of all, be listening to Mr. Rama, but then before then, we're going to take the presentation. So I don't know if you can identify the group representative that's supposed to do the presentations. If you're here, please kindly just use the raise your hand feature so I'll know who you are and then I'll call on you. But the Juliana GIPPCC Mentorship and Internship Program is a quarterly intellectual property mentorship program. The aim actually is to encourage education, intellectual property education amongst Nigerians. So it's for IP enthusiasts, it's for young lawyers, it's for young students, law students or not. It's for anyone who is interested in learning more about intellectual property. And the objective is to provide easy access to IP guidance, training, and resource material. So we have different mentors that come on the program and teach. And then we also have mentees who have the opportunity to make presentations and also ask questions, which is very important. So you can ask you ask questions and you have those questions answered by seasoned intellectual property professionals, lawyers, and other professionals as well, just like Mr. Rama is coming here to take us today. So if you are here, representative, can you just identify or not? Okay. If the person is not here, we'll just go on. A short brief on Professor Rama. He served as the director of WIPO Coordination Office in New York. He has been WIPO's representative since till the beginning of 2014 at the UN headquarters in New York, and currently he's holding the GNLU Microsoft chair. He worked with the Ministry of Foreign Affairs of India for nearly 25 years, became its chief legal advisor. He was also the legal advisor at the Permanent Mission of India to the United Nations in New York from 1995 to 1998. Earlier, he was a full-time professor at the Advanced Legal Studies Department of the University of Madras from 1977 to 1982, and he lectured at several universities in the US. He was an adjunct professor at Columbia University, Pace University Law School, New York, also a visiting faculty member at the Indian Academy for Diplomacy and International Law, the Indian Foreign Service Institute, executive member of the Indian Society of International Law, member of the SAARC Arbitration Council, member of the editorial board of Indian Journal of International Law and the Indian Yearbook of International Affairs, and an active member of the International Law Association in India branch. He's enrolled as a member of the bar at Delhi High Court and has several publications. And he has been the director of intellectual property and technology boards globally. So he's a bed of knowledge, and we stand to learn a lot from him. Thank you so much for joining us, sir.
Michelle, can I ask you one thing?
Yes, sir.
Am I visible in this side because I have a full background, or shall I turn another side and
so
show
it
you?
is visible, but not so visible. So you have the lights behind.
Okay, that is why. That's why I was asking you. Hold on 1 second.
No problem. All right.
Hold on.
Okay.
Is this any better?
This is better.
Okay.
Yes. Please, before we start, I just want to ask if maybe you have the network to your video. That's for the mentees. If you can turn on your video, so
Oh,
we can
it's
see each
turn
other.
on or turn off?
Not you, sir. The
Okay,
us in
okay,
the
okay,
studio.
okay.
Yes. If
Sorry,
you're
sorry.
hearing me, just
Sorry.
okay, sir. You have the floor, sir.
Okay, let me ask another instruction from Madame Juliana. Juliana, tell me, so I have 15 minutes, right?
Yes, you have about 15 to 20 minutes.
Okay. And so you can tell me to stop as soon as I start.
Okay, Rama, thank you.
Because I don't really know today whether the topic is small or big. This used to be like a, okay. So now I proceed.
Okay.
Yes, sir.
Okay, fine, thanks. But if I'm crossing, you always have that veto to stop me immediately after.
All right, sir. No problem, sir.
Okay. Thank you, Michelle, the moderator, Michelle Babasuyi.
Thank you, sir.
Where are you from?
I'm from Ondo State in Nigeria.
Oh, you are a Nigerian as well.
Yes, I am a
All
Nigerian as well.
Okay, cool. All right. Good afternoon to you there, and from here, good morning. And the topic that is given to me by Madame Juliana is Intellectual Property Treaties and Effects in Developing Countries. That is the topic. Now, plan to do would be to briefly mention about the intellectual property treaties and then the developing countries and see the issues and the solutions. It's all very briefly going to happen. WIPO, the World Intellectual Property Organization. Am I audible clearly?
Yes, sir, you're audible.
Okay, thank you.
Thank you.
World Intellectual Property Organization is the administering body for the International Intellectual Property Treaties. I think that is, okay, Intellectual Property Treaties. Now, there is a caveat here from my side. We're only speaking of the international intellectual property treaties, that is the multilateral IP treaties. I'm not going to get into the bilateral intellectual property treaties. There are bilateral treaties as well, but I might just say a touch and go anywhere, but I will not get into any specific intellectual property treaties bilateral. Because they could be important from different angles. And also, bilateral treaties, which may not be termed intellectual property as such, have intellectual property clauses in bilateral treaties. So those also I might not get into because of time limitation, but it's good enough for all of you to cap it right away that the non-intellectual property treaties containing intellectual property clauses are an important segment of international trade. And these relate in particular to the foreign investment treaties, the foreign capital or technology investment treaties. They're called the bilateral investment treaties. And there's a whole lot of law, policy, and economics, finance involved in that. But that's very relevant to us. So, but then that's altogether a different ball game, because you know what? You might know that most of the international arbitrations that take place today relate to the foreign investment bilateral treaties, which contain intellectual property protection clauses as well. Now, with that, let me leave that. The caveat itself is taking more time for me. Now, turning to the main topic, intellectual property treaties are, just to briefly know what they are, list out. Number one, there are 26 IP treaties administered by WIPO. Okay. Closely related to this are treaties about the plant varieties treaties, which also have intellectual property component of the modifications or the genetic modifications of seeds and plants. These are called the UPOV treaties. Then, in addition to the WIPO treaties related to patents, trademarks, industrial designs, copyrights. Okay, copyrights till the modern time. Copyrights that include the latest, which is the visually impaired persons treaty, VIP treaty, which also has an impact on developing countries. In addition to these, there is a copyright treaty that's also administered by UNESCO. And some of these treaties are also, particularly the copyright performance treaties, are also administered internationally along with WIPO and to a certain extent UNESCO by ILO also, International Labour Organization. Okay, now the last and the final, the big slap on our face is TRIPS. TRIPS is not administered by WIPO. TRIPS is administered by the World Trade Organization, which is the baby of Nigeria now, because we have the Director General. Now, WTO TRIPS underlines, I don't say undercuts, underlines all the international intellectual property treaties today. Okay, because WTO does not create new substantive intellectual property law, or has not created. Intellectual property law substantively, as contained in international treaties, existed before, mostly existed even before the establishment of WTO. But even after the establishment of WTO, some copyrights, digital treaties, etc., audiovisual performances, etc., all these treaties, WIPO copyright treaties, have all come after the WTO being established. So here, when we speak of intellectual property treaties, as we are speaking only of the international intellectual property treaties, we have an array of the treaties in different segments of intellectual property, covering patents, trademarks, industrial designs, copyrights, including the VIP treaty, as well as the UNESCO Treaty on Copyright, as well as the UPOVs on agriculture, plant varieties and breeds, and finally, TRIPS. This is the body, this is the, the corpus juris of international intellectual property treaties. Okay, now, this relating to developing countries. Developing countries were, when some of these treaties, like say the Paris, the Bern, or the Madrid, or the Hague, respectively on industrial property, on trademarks, on industrial designs, on copyrights, when they were made in late 1800s, the last 10, 15 years of 1800s, in the 19th century, what we call our developing countries today, you and I, were colonies. We were colonies for another century later. Okay, or half a century later. So we were not developing countries then. We were non-existent bodies of, we were not subjects of international law, not to speak of intellectual property, international intellectual property law. We were there like the animals lived in the forest, or the forest lived, in different continents. But we had no role to play, not to speak even of as developing countries. Now, as developing countries, we became, after the end of the Second World War, India and Ghana were one of the first from Asia and Africa to become independent, 1947 onwards. Then, of course, Latin America, South America was different. Latin America, South African, they became independent, perhaps along with American continent and later. But then, I don't want to get into it, but I cannot stop saying this, that the colonies of Asia and Africa, after colonialism, were ruled by the natives, the Africans, the Nigerians, or the Indians in India. But here, in the Latin American countries, or in America, Canada or United States, they're ruled by those that came and colonized, not by the indigenous people, not by the people from Amazon. So my friends, when we speak of developing countries, we got a whole demography, sociology, and jurisprudence of it to understand. Now, what we are speaking of today, I can't get into your brilliant brains, Michelle and Juliana, but I think you are speaking of the developing countries as we today see from Asia, Africa, Latin America, in the post-World War, okay, after United Nations was established, after we became United Nations members, after the end of colonialism, thanks to the 1960 United Nations Declaration on Colonialism, which ended colonialism legally through the aegis of the United Nations. And now, more particularly, you are speaking after the end of the Cold War, after the end of the bipolar world, and from the beginning of the WTO and globalization and the TRIPS. This happened when? This happened in 1995. So there is a whole history, but we are speaking of developing countries is only the ones after 1995, 25 years, 26 years. Okay. Now, my friends, for these developing countries, what is intellectual property? We were tools of intellectual property. I just want to give one example. In India, which was the first from Asia to become independent from Britain, India was ruled from 3 presidencies, they were called. One was Calcutta, the other was Bombay, the third was Madras. Okay, these were like the 3 sub-regional colonial capitals to run India. And today's most of the Gulf countries at that time were ruled from India as British colonies, including the Palestine. You know, Israel itself was established after 1947. Anyway, after United Nations. Anyway, an Indian, there was a patent office in Calcutta for India. If an Indian makes an innovation or a technology or a new innovation, it cannot be patented by an Indian. It can only be patented by a Britisher. Though the British law was applied to India as a colony, but Indian could not patent it, but a Britisher can patent it in England, in London Patent Office, but not in the Patent Office of Calcutta in India. That was the law. Now we Now we shift, absolutely forget about history. Now we come to 1995 onwards and TRIPS. TRIPS has embodied, TRIPS had applied, TRIPS was applied to the entire gamut of intellectual property treaties, all of them. Okay? Whether a country is a party to a particular intellectual property treaty or not, like several countries, you and mine, were not parties to most of these treaties. Even when I was a legal advisor in the foreign ministry in India, India was not a party to the Paris Treaty on industrial property. Can you imagine? Anyway, there's so much to speak. So here, but then once the TRIPS came into existence, whether like the Washington Treaty on Integrated Circuits was not even administered at that point in time by WIPO, and many countries did not become a party to it, and it did not even come into force. But still, because it got referred to under the TRIPS, so therefore, anyone who becomes a party to WTO and TRIPS becomes indirectly liable for the obligations under the Washington Treaty, for instance. Therefore, TRIPS does not, WTO does not produce substantive intellectual property law or international intellectual property law treaties. But all the existing intellectual property law treaties by then or later that came have all got the application of TRIPS to it, TRIPS to them, to that body of law, to that corpus juris. Okay. Now, becoming, how are you developing countries and your obligations to TRIPS? Number one, developing countries, whether you are a developing country or a developed country, once you are a party to the treaty, you are obliged legally under the provisions of the treaty, whatever it is. Any one of, for instance, the 26 treaties administered by WIPO. But if you're not a party to it, you are not obliged, right? But then now, thanks to TRIPS, of course, the clause that I said earlier applies. So therefore you get, whether you are a party to any treaty or not, you will become a party to them indirectly through TRIPS. Because why? Now, this is a catch. Now I am turning only to the aspect of TRIPS here in this connection. You become a party to it indirectly because you have to become a party to WTO. Why? The economy is globalized since 1991. Actually, intellectual property is related to trade for the first time. If you want to be a party, if Nigeria wants to be a party, if Kenya wants to be a party, if Algeria wants to be a party, or Indonesia wants to be a party to the global trade, if you don't want to be left out of the loop of the international trade encompasses all commodities, markets, goods, services, all. If you don't want to be left out, better join WTO. If you are not in WTO, you will never get a dime from anybody. There is no investment in your country. There is no technology that comes. Of course, all that is covered by the bilateral investment protection treaties. So you become a party to WTO. Once you become a party to WTO, you are automatically a party to TRIPS. You are a party to TRIPS, you are automatically a party to all international intellectual property treaties. You are a party to TRIPS, meaning your intellectual property or the intellectual property globally is there in the world becomes applicable to through trade to you and to your countries. You disobey, you break those rules, you become susceptible for two categories. Number one, the dispute settlement under the WTO, which is mandatory. And that dispute settlement can lead to trade sanctions. Trade sanctions, mind you, is not a single word. Sanctions you heard under the United Nations Security Council sanctions. That is only, it's like, but then here, sanction of the WTO is like, you cannot trade in food, agriculture, anything, name it. You can't trade with the other members of the, you are outright thrown out. Now that is the threat of intellectual properties the developing countries, as others would also face. Now, because I know the time is running out, let me run quickly on 2-3 bullet points and stop there. So therefore, today, the intellectual property treaties are an important bloodstream of developing countries' economies. What do intellectual property treaties do? You all know that intellectual property rights, IPRs, in patents or any other things, are exclusive rights to the rights holder, to the inventor, to the artist, to the scientific thing, to the guy who makes the computer, to the hardware owner, to Microsoft, to Zoom owner, to Google owner. They have the intellectual property rights. And you and I are not the creators, not the innovators, not the companies that produce and make profit. Only the intellectual property rights owners make the profits. Rest of the world, the consumers. You and I are the consumers. We are the consumers of the trademark. So we do not want confusion in the trademark. We want the same Zoom, we want the same McDonald's, but we don't want any, diluted stuff coming out of it. And that monopoly right is vested through intellectual property rights. These are different boxes of monopoly, exclusive rights, and we are all users. And these mean that without our knowledge, we are paying into the owners for their inventions, for their copyrights, for their trademarks. We are paying it. We are paying it directly, or the ads that come when we watch the TV are the ones that are paying. So the broadcast is a monopoly, the ad is a subscriber, and we are the consumers, but the profit goes to them. And this is governed by the intellectual property, so far as the TV is concerned, by trademarks, patents, and copyrights as well, the broadcasting rights as well. Now, so the intellectual property rights, the monopoly rights are there for the monopolists and the capitalists, and they are all protected by the intellectual property, international intellectual property treaties. We call it international because these are cross-boundary rights. These are global rights. Under TRIPS or under specific treaties, these are global rights with reference to the parties to those treaties. So the integrated circuits, the computers, the computer data, all of them belong to the same patents and copyrights scenario. Now, what happens to the developing countries? Quickly, let me say. Developing countries want development. With specific reference to intellectual property treaties, they are not the creators mostly. They are the consumers. They are the consumers in the sense they are necessary consumers. If you and I do not have the computer with us, a computer is a solid hardware intellectual property tool. The programs they are there are the copyright algorithms, the trademarks that are there of these Apples or Googles or Microsofts or blah, 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 or whatever, or the Samsungs and the iPhones and the phones, etc. These are all the owners, okay? Now, we cannot live in this world without intellectual property. But we are not the creators. We are not the owners of the science, technology, innovation, STI. And STI is the economics of the world today. It is no longer the the mines, the natural bauxites and the copper produced in Africa. But that is true. We need them for the chips. But this is essentially the intellectual property rights, which you cannot touch and feel, but they are the rights, intangible assets. Okay. Now, what the developing countries want? The developing countries, during the TRIPS negotiations, in the Uruguay round, developing countries opposed, like say India, Brazil, at that point in time, in late 80s in Uruguay round and early 90s, and the African countries opposed this. We said, we don't want the linkage of intellectual property rights to trade. We want to trade, but don't put intellectual property because we don't know what the hell it is. Okay, the developing countries at that time opposed the linkage of intellectual property rights to trades and to the existence of TRIPS. There cometh the question of flexibilities. You all know in TRIPS flexibilities, there are two kinds. So far as we are concerned, one is for developing countries as a whole. The second is for LDCs, least developed countries. And most of us are also least developed countries. And what are developing countries? What are least developed countries? These are decided by the United Nations in the second committee, the Economic Social Committee, through the Economic Social Council called ECOSOC, on the basis of the UNDP Human Rights Index, on the basis of the GDP and the per capita income. That is how these countries are decided. The national product, GDP, gross domestic product, that's how we decided. And now they're not decided by WTO or WIPO. But once they are there, according to TRIPS, these people in 1995, when this came into existence, TRIPS came into existence, they were given different flexibilities. I don't want to go into the whole lot of TRIPS law, but then these relate to more time today, as of now. The LDCs, anyway, this question came up big time in the health sector for HIV/AIDS in 2000. Like today in 2020 and 2021, we are speaking of COVID-19, and today we are speaking of the Delta variant. And earlier we spoke of, Alpha, Gamma, Beta, South Africa, London, etc. variants. Today we are speaking of the Indian or Delta variant. Similarly, 21 years ago or 25 years ago, 22 years ago, in the United Nations, we used to speak of HIV/AIDS. During that time, there came up, so far as we are relevant, I cannot get into too much because I'm getting excited about the topic. It's relevant to us because there, on the HIV/AIDS, Doha, a conference was convened. Why? Because the developing countries said, 70% of the HIV/AIDS inflicted people are in sub-Saharan Africa. People are dying like flies by the morning. Okay? And this was imported from abroad. Now we can't do anything, but the medicines were available. They were patented. They were patented by two scientists in Yale University. And then they were taken over by the GlaxoSmithKline and another company. The medicines were available in 2000 per head, per annum. HIV/AIDS medicines, that's called a triple therapy, costed $50,000 per head. And in sub-Saharan Africa, in 221 years ago, what would have been the per capita income of an HIV/AIDS patient? You were speaking of less than $1,000 or $200, and the medicine is available to save his life or her life, and then it is $50,000 per head. Government cannot buy and give. By then, India had a generic industry, and India offered to produce the same therapeutic thing by going back into that, because India was not bound for that purpose under TRIPS, because India did not recognize the product patents, it recognized only the process patents. So it could undo the process of GlaxoSmithKline and produce through its own separate process the same product, and which is not prohibited because India had 5 years or 10 years to do that, to become a party under the flexibilities clause. But then Brazil was dragged because India said they would give to Brazil and to South Africa, and they were dragged to WTO dispute settlement panel. India was stopped. India said it will supply $1 per day. The same medicine, which was costing $50,000 or more. India at that time, a company called Cipla, said it would supply the same material, same medicine to save lives, $1 a day. Are also under the technical agreements between India and African countries. That was stopped. Here, what I'm saying is, today in COVID-19, South Africa and India and the whole of Africa is supporting, and there are 127 countries now, over 100 countries supporting the waiver of TRIPS waiver for supply of whatever Covishield and Covaxin for COVID-19. Now here, this is a problem of developing countries. We have intellectual property treaties, international intellectual property treaties, like the patent treaties, the whole lot of them. And we have the treaty of the TRIPS. All of them prohibit. Biden luckily came and said he would support. Europe is opposing it even today. Okay, now we have a problem. What is its effects? Coming back to the topic, international intellectual property treaties, as I would say, and effects on developing countries. It has an effect. The patents have an effect in the health sector. It have an effect on the pharmaceutical medicines. Okay, now we have same thing on the copyrights. In the copyrights conventions, starting from the 1890s Bonn Convention, we have something called a 3-step test. I'm sure you all know it. But if you don't know, follow me, because this is a substantive part of copyright law. 3-step test is Article 9.2 of the Bern, and later it is followed in all the umpteen copyright treaties, including to the WIPO copyright treaty or to the visually impaired treaty, VPT, to all of them. 3-step test is that exceptions, limited exceptions can be made to copyright, which is normally 50 years. Could be more, but at the minimum standards. But they should not unreasonably interfere with the copyright whatever thing, and should not hamper on the authors or scientists' control over them, and for which remuneration has to be paid. If the 3 steps are accepted, then you can make an exception, otherwise not. Now what happens here? We have copyright originally only for dance and music and performance and plays, etc., which itself is a big economy for, say, the Trinidad steel brass things, or for the music from Africa. Okay, but then there is a fair use. Fair use is that if it's only for purposes of research, or if it's only for purposes of education, you could use it. Fair use exception. Okay. Now, this is a common exception, but other exceptions are if the whole computerization and if the entire data is protected by copyright, and Africa and Asia and Latin America are not producing, and these are protected by the multiple intellectual property laws, including patents, through international intellectual property law treaties. Treaties are the international law documents. Then what will these people do? We were cut off from the digital world. Then came the movement of the WPT and WCT. Now, this is where the North-South dialogue is. North-South dialogue is what except the rights are owned by the developed. The users are there in the developed countries, but most of the developing countries are users. Most developing countries are not the producers of intellectual property. Therefore, that is the North-South dialogue. To match up these two, how to do. Now, while WTO was only concerned with the implementation of TRIPS, WIPO picked it up, or the developing countries picked it up in WIPO from 2000, particularly after the Doha Declaration, which provided a kind of health exception under Article 31C of the compulsory licensing of TRIPS, which is a favorable exception, in addition to the TRIPS flexibilities of the duration, which today the TRIPS is available for the LDCs countries till 2033. The health exception for compulsory licensing is available till 2034, meaning thereby that for the LDCs countries, you are not bound by these patents. Originally, you can get it only from those companies that produced it. But after a later amendment, because of the developing countries like India, it came to the extent that while in 2000, the Indian export to Africa was stopped by WTO for HIV/AIDS, today for COVID, India can export to South Africa or to any other countries in Africa the medicines that they have made with reverse engineering. They can export those medicines under TRIPS exemption of health-related 31C compulsory licensing. And this is given for the generic industry also to do it, so that that could be better. Now, North-South dialogue. So WIPO has taken up development agenda. Development agenda, the World Intellectual Property Development Agenda is to inculcate, to bring down the TRIPS prescriptions and requirements through the intellectual property treaties to flexibly accommodate and to take care of the interests, the backdrops or the drawbacks of the developing countries in order to meet their social and developmental needs. That is WIPO Development Agenda, which was passed in 2007. It was divided under five clusters. Under this, WIPO offers to developing countries and the LDCs certain services in all earmarked intellectual property areas, including training. That is where we get into this WIPO Academy, distance learning or classes, all those things, Geneva or Turin or Korea or whatever. All those things are classes held in Abuja through WIPO collaboration. And then TISCs, Technology Innovation Centers, RD. So many of those skills and tools are given through this. Now, I am sure I have finished my time, but give me 1 minute, Juliana. Is it okay?
Yes, sir.
Okay. Okay, thanks. I just want to say one thing. It is the reverse point. The reverse point is this. While so far, why these people, the developed countries, want to execute through intellectual property treaties these sanctions and these high-handed economic behavior on developing countries? All right, clearly it is for their behavior, for their benefit. If not, they would immediately accuse the developing countries of piracy. You are taking our quality product, you are pirating it and selling it under either a different brand or under our brand, you are selling third-rate goods, which are not of the same quality, and that impacts on our trademark, and that impacts on our profits. our profits. Basically, the governments of the Western economies are campaigning in terms of intellectual property enforcement for the down-to-earth benefits and profits of the multinational corporations located in their countries, which run their economy and their governments. Okay. Now, what are the developing countries saying? All right, we got it. Now, what we are saying is, you are taking biopiracy, the Pfizer's anti-obesity drug is taken out of the Polynesian green leaves, which I forgot the name. They used to use it for in Pacific, South Pacific, these islands. They used to use for drinking, like it's not like alcohol, but they drink a portion of those juices for them to get, for a baby is born, they're celebrating. There's a death in the village, the community. So they were mourning. For all those things, they would drink that. And that drink, Pfizer found out through research that this works for anti-obesity. And now that becomes $1 billion drug here. Now, from Madagascar, we have the rosy periwinkle. Rosy periwinkle was the basic ingredient, the leaves DNA material that is used for the cancer, particularly the Bavarian cancer. And that became $1 billion industry in the world. Or there are so many other things about the traditional knowledge of Africa, Asia, Latin America, or the Chinese medicine, ancient Chinese medicine, or Indian medicines of Ayurveda. Now this, from 1990s, when this reverse engineering has started, this is the first time the Africans and the Asians and the Latin American countries, the Amazons and the indigenous people of Amazon who knew the value of what it means for millions of years said, this is biopiracy by the Western countries and the Western corporations. Now we have in intellectual property issues of traditional knowledge, traditional cultural expressions, and genetic resources. There again, my friends, we have international treaties, CBD, Biological Diversity Convention. We have Nagoya Protocol dealing with the environment aspects. So what we are asking therefore, along with the indigenous peoples or the tribes, is free and prior informed consent of the original holders of these rights, of these materials. And access to those materials that are produced out of this, those medicines or whatever, and for a share in the benefits that are accrued out of this business. So ABS, access to benefit sharing, FPIC, free and prior informed consent. These are some of the things. I will stop here. Thank you.
Thank you so much, sir. Thank you so much, sir. So we're going to have 1 minute to ask our questions. I'm sure we have a lot. Even I have it. So you can write it in the chat or you can unmute yourself and ask so that Mr. Rama will answer the questions for us. Let's just take some time to.
I think someone has already asked a question in the chat box. So if you have a question, please just unmute yourself and ask your question. But while we're doing that, please, I would like to acknowledge Mr. Fola. He's also a mentor and he's present here. So I would like to acknowledge his attendance. Okay, so if you have a question, please kindly ask. Michelle, maybe you just go ahead and read Samuel's question.
All right. So our first question here from Samuel. There seems to be a dichotomy in the way intellectual property is viewed from the so-called developed countries and the developing countries. Does this exist in reality? If it does, why does it exist? And can anything be done about it? Should I go again? Slowly.
I go for it.
Yes, sir, please.
Okay. Thanks. It does exist. It does exist. Say, in the concrete example of what we have said is about the medicines, access to medicines, access to drugs, Doha Declaration, and the current resolution before the WTO TRIPS Council and the Assembly about the access. Question here is the developed, like say where I am in New York, in United States. This is an anomaly. In United States, there is a whole lot of availability of vaccines for COVID-19. Okay. Some states, people have gone for vaccination. In some states, so-called Republican states, they think this medicine is a democratic propaganda. They don't want to have vaccines. They think there's opposed to it. Now, but there's a whole continents of Asia, Africa, Latin America, where there is no vaccination. People want to get vaccinated. They don't want to die. Because even Delta variant, you can survive. It won't kill you if you had double vaccinated, as per whatever the requirements of the particular vaccines. But here is a case where you have vaccines, but some don't want to get vaccinated. Now, that is why in WTO TRIPS, India and South Africa, and now the whole lot of developing countries, they are asking for waive not only the patent, but the entire intellectual property waiver. Do it. Because why I'm saying this is, it's not only the patent for the vaccines that is there, but there is a non-patented data which goes into the making of the medicine and the properties of the medicine. Unless you know the compounds of the medicine and the ratio, you cannot produce in a generic industry by reverse engineering. And because either you wait for these companies to produce enough and they give you only after they meet their developed countries' market requirements. Meanwhile, your people will be dying in hordes. So if you want to save them, you can give to, say, India or Brazil, somewhere where there is reverse engineering generic industry, but then they cannot produce it by patent waiver unless they know the secret, trade secret of the compounds and the mixture, and that is trade secret ed. That's why they are asking for intellectual property waiver in TRIPS, not patent waiver alone. That's another controversy between Europe and these countries right now going on. So now the question is, developed countries and developing countries, does this exist in reality? Of course it does exist in reality. It exists in reality because intellectual property and science and technology is the backbone of industrialization and computerization, Silicon Valley, and whatever you say. And you are a developing country because you don't have science, technology, and innovation. What we need to do is this is the defining divide between developed and developing countries. Divide is STI and capital and science, technology, and investment. Therefore, I would say, yes, it does exist, and it is a reality. It is a reality recognized by all, developed and developing. But I have a message to give on this before anybody else asks me a question. My message is, developing countries will remain developing. You name any country, it will remain developing so long as you don't improvise on your science, technology, innovation, infrastructure, your manpower, the human resources, the scientists. All the Nigerian doctors are in London and in New York. They are not, as I keep saying, they are not in Lagos and Abuja. But why? Why are we looking for greener markets? What are we doing for our people? What are our governments doing for our societies? This is where we have to work. Unless the dichotomy is here, unless you enter into a foreign bilateral investment treaty, meaning that a corporation, multinational corporation invests in Nigeria under an agreement that they take their 200% of the profits they take. That is called RTI in economics, return on investment. They will take the return on investment, ROI, they take it, only then they will invest in you. And then they bring their technology for which you have to protect. Then when is your own domestic technology producing? When will you be able to produce the goods for yourself and the technology to other countries to transfer and make profit? When will that come? That will come only when you have infrastructure, manpower, and your own capital and this. Therefore, the mission for developing countries in intellectual property field, particularly for intellectual property rights, is that we have to develop our own indigenous STI, science, technology, and innovation. Thanks.
Thank you, sir. Please, Mr. Folarin, do you have anything to add to anything he has said or any answer to the question?
No, I don't think I have anything to add. I think that was a fantastic presentation. I got quite excited, with the information that was thrown at us. It's been a very interesting, informative and educative session. Professor Rama really has been in the thick of things, and I remember when he made reference to the reaction of developed countries to the initial reaction of developed countries to TRIPS and the introduction of IP to trade. I just smiled and thought, it's quite interesting. All these facts or these pieces of history actually go a long way to, in terms of it does help us. These are things that you will not find, of course you can't find in the provisions of any of these agreements or treaties, but it's a part of history that provides context, that can also help us in formulating our own local policies and laws. So it was a fantastic presentation. I would like to know, though, maybe just an aside, what Professor Rama's thoughts are on. And I'm sorry, my camera is not up. I was in court earlier. I just got back from court. But I'd like to know Professor Rama's thoughts on the effect of leapfrogging, especially with regards to technology for developing countries or less developed countries. How do you think we can overcome some of the challenges that leapfrogging has caused? We didn't get to go through all the stages of development, and then here we are being introduced to new technology, and that's a problem. For example, our Patents Act in Nigeria does not provide for substantive examination of patent applications. So what the Act provides for is that once the formal requirements for registration have been met, then the registrar of patents must issue a patent certificate. But what the Act then does is the Act now states that the patent certificates are granted without any guarantee as to validity. So we essentially have a patent system, for example, that does not require a substantive examination of the patent application at all. But we want to grow our system to a point where we can actually start to have or we can encourage invention or inventive activity by adopting some kind of or having some kind of substantive what's it called? Substantive examination. What this does is it removes that caveat from because at the moment the patent certificates, the act doesn't give a guarantee as to its validity. So it's only valid until when it's tested in court. That's really the implication. So how do we transition from that system, or from a system where almost any application flies, to a system where we can, a system that is much more robust? So I guess it started as one question, but my main question, the real question really is, what are your thoughts on leapfrogging and its effect, especially in technology space, on less developed countries? Thank you, sir. Thank you, Professor Rama.
Thank you, Mr. Folarin Aluko. Well, more than one question, but very deep questions they are, well thought out. Let me say first, the first is the leapfrogging in the technology sphere. Now, this is both sides of the coin, leapfrogging. One is that how can we leapfrog? And the advantages of snail pacing, or disadvantages of that, or advantages of leapfrogging, and the possibilities, practicability of that. I think this needs to be really seen in the obtaining context, and it fits into the overall developmental policy of the country. How the country means a government at a point in time, or country as a whole, if the governments continue the same economic philosophy, perspective, because something like some examples we can see, like for instance, Korea, or at some stage Japan, or some stage China. I think Korea, I mean South Korea, they have kind of leapfrogged. Now, there is this, or you can, if you take the example of United States might have not necessarily leapfrogged, but always had one step forward, but kept a step ahead. So, but how does that apply to us in developing countries and LDCs? It's not an easy question to answer. As I would say, it depends upon the developmental priorities and the governmental regulations. Because, like for instance, like today, the individuals like Amazon's Bezos or the Virgin Atlantic guy, they go to outer space and come back. They go to moon and come back. Individuals can do that. Can a country in Africa do that? Is it necessary to do that? Is it our priority to do that? Or does our priority lie in educating all the boys and girls of our countries and giving them education in science, engineering, and technology, and trying to patent their inventions and recognize their inventions and encourage them and patent them and market them? What is it we have to do? So we don't know. I mean, but then on the other hand, how come, South Korea goes from wherever it was in 1950 and the country got divided into two, and North Korea remains the same, and South Korea is now the, is the Samsung, whatever, Samsung owner and all that, competing with iPhone, etc. So I would say there's not one answer, but I'm not opposed to leapfrogging, because the downside of not leapfrogging and going at snail pace is that we remain the same for another century. Do we want to be so? I would like to say no, because I am a great champion of science, technology, and innovation. But I do understand how we have to attain it there. But then it requires a policy. It's not just magic wand overnight that becomes. No, it does not. Okay. Now, the other question of the patents and, you're not examining, say, the substantive examination before issuing the patent certificate, and then it is left to the litigation. I think that can be fixed. That can be fixed, and I think WIPO should also assist in that. And of course, the Nigerian Patent Office and Industrial Property Office and the Copyright Offices have close connections in WIPO, and they have close connections with the USPTO and EPO also. I think I would say that substantive examination, I mean, particularly a country like Nigeria, will have to do substantive examination. There's no, I would say, go beyond the patent certification before and then grant a proper patent. And because your examiners can be trained, or we can train new examiners and recruit them for the patent office. And I would sincerely support, and I hope there are ways, and there is that much of technical assistance possible. And also, particularly for Nigeria, I would say that you have to go to actual the TISC's positions and make complete use of them. And now that you have WIPO office as well, you should do more, and other countries as well. Thanks.
Thank you, sir.
Thank you very much, sir. That was fantastic answers. Thank you, sir.
Thank you, Paula Rinaloko.
Yes.
Do you have any other questions? Anybody else with a question? All right.
How many are there in the program now?
Sir?
So what's your question?
How many are there in the program? Oh, there is a question?
No. There is no question. We're about 18, but okay. Those present are 9 now because some have left. Some are being called to the bar today.
Okay.
There's Nigerian call to bar today, so some of the mentees are there, so they are not around today.
Yeah.
Thank you, Rama. Thank you for an amazing presentation, and I've learned a lot from the presentation personally, because now I know that as countries that are developing, we have to stand for forward movement. So we have to decide what exactly we want and how we want to achieve it. We also have to try to invest in R&D, because research and development is very important. As you stated, capital, science, technology, innovation, and infrastructure is very important for countries that are developing. And it's not enough for us to have things that are indigenous to us. People come, pick it up, work on it, and then we then buy and start consuming. We have to think of a way that we can produce and also be selling these things to them so that they consume from us. And I think that's what you've been able to pass across today. So thank you so much for talking about TRIPS, talking about WIPO's position on least developing countries and the trainings that they are doing and everything. And we hope that with forums like this, with awareness, that we would get to a point where we are a developed country and move from being a least developed country. Thank you very much, Rama.
Thank you very much, Juliana. It's a wonderful opportunity, and you have summed up so well that I have no word to add. I entirely 200% agree with what you have said. And that is the way forward. That is the way forward for LDCs and developing countries. And intellectual property is a tool for our growth.
Thank you, Rama.
Thank you, Juliana. Take care.
Michelle, do you have any other thing to add?
No, I don't have anything. I just same with what everybody. I basically have undergone an eye-opening experience today. I never thought of it like that. So when I was doing my project on image rights, and my project was focused on how there were no image rights laws, and then I had other colleagues to doing other courses and just comparing how in Nigeria and Africa we didn't have so many laws, and a lot of it was okay. We're not doing enough. We're not doing it. But I never really thought of the fact that in international spaces, not to place the blame or anything, but we were kind of being it's kind of a power grab between the developed countries, to the extent that they just discard, or maybe they don't respect the ideas and the needs of developing countries. So I learned a lot from that today. But thank you so much, sir.
Thank you very much, Juliana, and thank you, Michelle, so much. I think call me every week to Nigeria.
Of course, Rama. We'd love to have you here.
Thank you so much.
Thank you.
Thank you so much. Have a good evening.
Thank you, Rama. Have a lovely evening also. Bye.
Bye.
Thank you, everyone.
Thank you.
Take care. Bye.
Bye.